Welcome to Red, White, and Blue. I'm Gary Polland. Dallas Jones is off this week, and this week we have an interesting topic, the Supreme Court. We've talked about it for 17 years. Every year we have a Supreme Court show. Every year we have great guests who are the brightest legal minds we have in our region, and today we have two of them. First, Emily Berman, Associate Professor at University of Houston Law Center. Welcome, Emily. And Josh Blackman, second or third timer, Associate Professor of Law at South Texas College of Law. Welcome to both of you.
Thank you.
Thank you.
All right, so we're in another interesting year, and actually I'm going to flip it. Let's start by talking about, we talked pre-show about what we're going to talk about, for 3 minutes. And we have 27 minutes to go. But I want to talk about the court, because the court has new members this last term. And I'd like, I'll start with you, Emily, ladies first. Your take on the impact of the new justices.
Well, certainly there's a big impact. Not necessarily exactly what people maybe would have anticipated, but I think definitely Anthony Kennedy having left the court, Justice Roberts is very clearly the swing justice now, and so that brings the center of the court decidedly to the right. I think with Justices Gorsuch and Kavanaugh, there is an interesting differences they're both very conservative justices, but interesting differences in their brand of conservatism, and I think they weren't in agreement last term as many times as people thought they might be. So it'll be interesting to see how that relationship develops.
Okay, your take, Josh, on the new personalities?
Well, for the longest time, Justice Anthony Kennedy was a deciding vote in every case, and Emily is exactly right. He's no longer. Kennedy was replaced by Justice Brett Kavanaugh, and earlier the prior year, Scalia was replaced by Neil Gorsuch. We have these two new justices who I think are going to surprise us a bit. But what's going forward is we have now a conservative president, a conservative court, and an increasingly hostile branch of government from Congress who are annoyed and angry at the court. And in fact, members of Congress are sending the court briefs and letters and all these pleadings saying, be careful, right? If you rule in certain ways, we may have to do something about it. And so we have things like court packing and court reform, as we call it euphemistically, on the horizon. So I think the tensions between the courts and the political branches are only going to increase and not decrease in the coming years.
Emily, do you think that the court is going to resist political pressure from Democrats or Republicans, that you need to vote our way, or we're going to add 6 members and change things?
Well, it's certainly not going to be explicitly any sort of response to all of the political noise that's being made. But I do think they can't help but, they live in the same world we do. They live in Washington, D.C. They can't help but be aware of those sorts of tensions. And I think we even saw it in the last term. Chief Justice Roberts is very conscious of the court's reputation and maintaining the legitimacy of the court. And so I think it does impact both the way he rules on things, the cases that they take, is all done with consciousness of the environment that they're working in an effort to stave off any efforts by Congress to change the court.
Yeah, court packing, I think I've looked at the polls, the people are not really big on that idea.
Right, and keep in mind that not only do we think about the Supreme Court, but there are lower courts. And most cases that are ever decided are not decided by the 9 people in Washington. They're decided by judges in Houston and New Orleans and in New York City and in Dallas, elsewhere, who decide most of the cases. I seriously think that given the current trajectory of the courts, we may see an effort not just to pack the Supreme Court, but perhaps to expand the size of the lower courts to offset President Trump's very successful rate of putting federal judges on the bench.
Yeah, they've certainly been relentless, Emily, in terms of appointing judges, which of course that's their right to do. And they're putting lots of younger, bright conservatives on these benches around the country, and they're going to be around for 30 years.
They are.
Or longer.
That's the other thing, when you mentioned how long they're going to be around, the other idea that people have floated about the Supreme Court, which I think probably has more support than adding to the number of justices on the court, is imposing some sort of term limits on the justices themselves. Of course, I think it's sort of equally as politically likely to happen, which is to say, not at all. But there are people who say, maybe people shouldn't be on the court until they're 85, 90 years old. They spend 40 years on the court, and then in addition to the benefits that would have just for the vitality of the court, it would also mean if the justices had to retire at fixed times, then each president would have a fixed number of appointments to make, and it might depoliticize a little bit the appointments process,
Well,
which,
that's an
as you
interesting
know,
idea.
is
So you think they should have a
problem.
retirement? You support retirement age?
I don't know
at
if I
some point?
support it. I think I definitely am more in favor of that than adding to the number of justices. I think it's a better way to address the concerns that people have, because Democrats add 2 justices, the Republicans add, we're going to end up with 60 Supreme Court justices.
Well, yeah, if the Democrats get away with court packing the first time, then when the Republicans, this is like a political pattern, right? It's kind of like not getting along in Washington, not passing, not cooperating anything. One side does it to the other side does it to them. When they get their chance, same thing would happen. You're right. Mm-hmm. We'll pack the court more. Mm-hmm. We'll pack the court more, and then the court will have the American people will have no respect, because there's a bunch of hack politicians. Yeah. And the hack politicians, by the way, are popularity are significantly lower than President Trump. I think Congress's popularity is around 15%, with good reason, since they don't do anything, right? Yeah. Except raise hell and complain and whine. Okay, let's move to it. So let's talk about this term. Supreme Court does do things. They do hear cases, and they make decisions. We do not always like them, but they make decisions. So first case that I found in researching this show was New York State Rifle Association versus New York City. Who wants that?
I'll take it.
Okay, what's it about?
This case involves guns and the Second Amendment. Nearly a decade ago, in a case called District of Columbia versus Heller, the Supreme Court said that the Second Amendment protects a right to bear arms for self-defense, not a right to bear arms in service of a militia. Since then, the court hasn't said much about the Second Amendment, almost nothing at all, in fact. This case considers whether you have a right to carry a gun outside the home. And the facts are complicated, but New York makes you get special types of permits to transport your gun outside the home, has to be locked up, etc. This is a very basic case. This is not about open carrying. It's not even about concealed carrying. It's can you actually transport the gun from your home to a shooting range without getting special permission from the government? It's a fairly narrow issue. Now, you might say, of course you should be able to do that. Well, the case is complicated because New York has gone out of its way to stop it. New York has changed the law so that you no longer need a permit to carry a gun in this fashion. They've tried to what we call moot the case, to get rid of it. Oh. Now the court has to decide, is this case even still a live controversy? Because if the law is not in effect, what the heck's the point? Now there's some rules that when the government tries to stop a case midstream, sometimes the courts can still keep it. Controversial. But I think there's a good chance the court dumps the case and just waits for another Second Amendment case from, I don't know, New Jersey, right across the Hudson. There are far better cases than this one to take.
Emily, you have any comments on this?
Yeah, I agree with that. I think the court is eager to take up more Second Amendment cases, but I think that maintaining this case on their docket, given the changes in circumstance, would represent a really aggressive move on the court's point to keep the case. And so I'm sure there are Second Amendment cases that come to them every day, and they can pick one of those.
In fact, Josh, Texas law about carrying a weapon. In Texas, you are legally allowed to carry a weapon from your home to a shooting range.
Or anywhere else in between. Right. As long as there's no big sign on the wall saying you can't, you can bring a gun anywhere, even on this campus.
Even to my classroom.
Yeah.
Really?
Mm-hmm.
I teach at a private school, so we don't have that rule. But Emily does.
Really?
Yeah.
So how many of your students carry, Emily?
It has to be concealed carry, so
well, the good news
I'm
about
blissfully ignorant.
Yes, the good news about concealed carry is I think that we did a show on guns. The statistics on concealed carry permit holders who committed violent crimes was like infinitesimal, 0.1% of the holders. So it's quite low.
Well,
so
that's
I think
comforting.
So you should be okay, but you should get your own. You'll be okay. You get a purse, right? Okay. Next up. DHS versus the Regents of the University of California. Emily, let you go with that first.
So this is the latest chapter in the fight over what's known as the Deferred Action for Childhood Arrivals program. So this is the program that President Obama initially implemented to defer deportation of people who had been brought to the U.S. through no fault of their own when they were children and were undocumented. And there are about 700,000 of them in the country now that were able to stay and go to school and work, and it was this temporary status. President President Trump, when he came into office, decided that he didn't want to keep the DACA program, and so rescinded this program. And as with everything else these days in politics, that political move sparked a lawsuit. And so the suit is about whether President Trump and his administration acted properly in rescinding President Obama's DACA program.
Which was an executive order, right?
It was.
So in theory, the president can invoke an executive order and then he can revoke it, right?
In theory. I think this case is an interesting example of something we've seen on multiple occasions in the Trump administration, is nobody's saying you don't have the power to do it, you just can't do it like that. And it's another instance of not having followed proper procedures, doing something that would have been relatively simple.
I mean government by tweet.
You might call it that.
Okay, I have a problem with that too. Okay, your take, Josh?
Well, this case has a very Texas flavor to it. The Texas Attorney General threatened to sue President Trump unless he wound down DACA.
Right.
And indeed, Trump did wind down DACA after that. There's also a case pending in federal court here in Texas about whether DACA is unlawful. So even if the court decides to punt in this case, there's still the question of, is the policy legal? So I expect the court to actually decide if the policy is legal, not just to decide on whether the rescinding is lawful. And I think there's a very good chance that Trump prevails in this. The lower courts all ruled against President Trump, and the Supreme Court granted review. Generally, when the court grants review, they grant review to correct an error and to reverse the lower court. So the fact the court took this case tells me that they're probably going to allow the president to wind down the policy.
Would the case become moot if a miracle happened and there was a compromise in Congress on DACA reform?
Well, I think that would be wonderful if that happened.
In fact, I've been thinking about this case, and I'm here as a lawyer, not as a political consultant, but I think for the president and his administration, it might almost be better if he lost this case than he has the courts as a foil to blame. But meanwhile, the dreamers, as they're called, are very sympathetic plaintiffs, and you end this program, and now there are 700,000 people here in sort of a legal limbo. I think that's not going to be a very popular position to put them in, and I think it'll put a lot more pressure on the political side to find a solution.
Yeah, well, it doesn't look like the parties in Congress are going to agree the sun's shining at this point. I may be missing something. Okay, interesting case. Okay, how about Zarda versus Altitude Express? Josh?
This case concerns whether federal law prohibits discrimination against people based on their sexual identity, based on sexual orientation and gender identity. We know about 5 years ago the court ruled that the 14th Amendment protects the right to same-sex marriage. But it doesn't say much beyond that. This case is about federal anti-discrimination law. In 1964, Congress enacted this significant legislation called the Civil Rights Act, which says that you cannot discriminate on the basis of race, on the basis of nationality, on the basis of religion, and on the basis of sex. What does sex mean? What does it mean to discriminate on the basis of sex? And that's actually a really intricate question. And this case presents the question, does the 64 Act, does the Civil Rights Act prohibit discriminating on the basis of a person's sexual orientation? And there's another case about whether it prohibits discrimination on the basis of gender identity. And the lower courts have actually divided on this question. Some have ruled that no, these laws were enacted 50 years ago.
Nobody
they can't
knew
possibly even cover something like gender identity.
No.
It didn't exist yet.
No.
And other courts have said that if you take the word sex to be as it's understood, it would embrace a person's attractions based on sex, and it would also embrace a person's a nonconformity with sexual stereotypes. So there are a lot of arguments on both sides, and I think we'll see a decision. I don't want to make a prediction, but I think this case will have a lot of, I think, compelling arguments on both sides.
Emily?
Yeah, I think a couple things about this case. First, bit of trivia. The addition of the word sex to the list of things on the basis of which you may not discriminate was actually proposed by a Southern Democrat who was trying to kill the Civil Rights Act and thought that by adding sex discrimination as part of the prohibited actions that nobody could possibly vote for such a bill. But
Fascinating.
here we are. I think one thing I'm looking for here is all of the earlier cases that might be considered sort of about LGBTQ rights have been really turned on Justice Kennedy's vote, and Justice Kennedy was the author of all of those decisions.
Right.
And so this is going to be an area where we're really going to see, what does the absence of Justice Kennedy do for this particular area of law?
It's interesting. That'll be an interesting, hard-fought decision. Okay. Well, then we're down to Espinosa versus Montana Department of Revenue. Emily.
Yeah, so this is a case out of Montana about school vouchers and whether school vouchers that represent government funding can be used by parents who want to send their children to religious school. And it's sort of the latest in a series of cases about what sorts of entanglements between the government and religion are permissible. A couple terms ago, we had a case that was about whether a school could use federal funding to refinish a playground. And the question...
We discussed that on the show.
I remember.
And the court came down and said, if non-religious schools can have this money for their playgrounds, religious schools can have their money for these playgrounds. And Justice, I think it was Roberts, was very careful to note in that case, we are only talking about playground resurfacing here. So now, we'll see, put his money where his mouth is, and my expectation would be that these kinds of cases are going to go the same way that one did, and we'll see sort of an expansion of the court's protection of free exercise of religion in that way.
That'd be very interesting. Let me bring a topic up that I would like to discuss. That it seems like this started under President Obama. It's obviously accelerated under President Trump. It's run into the courts to go on every public policy dispute. Any action taken by the government, by the administration, again, both Obama and Trump, the opposite sides ran to court, filed lawsuits on this and on Obamacare. Started with Obamacare, I guess, and then just is continued on and on. Trump announces a decision on Twitter, and they have a lawsuit filed the next day. I mean, it's like I don't know. I want to know what your take is, starting with you, Emily.
I think that I have a couple of thoughts on this. So the first is that I think this is a product of the legislative dysfunction in Congress, that people are frustrated that you can't get something done through the political process that was designed to do it, and therefore, rather than sit on their hands, administrations want to take action, which is understandable. So I think that is sort of what's driving the trend that you pointed out. I would also argue that when it comes to President Trump, it has accelerated quite a bit, I would argue, because he has introduced policies that are much more extreme, much more controversial, much more questionably legal, I would say, than previous presidents. And so I think it's a function both of Congress's dysfunction, but also this particular administration.
Josh?
Well, de Tocqueville wrote nearly 200 years ago that in America, every dispute goes to the courts. So there's nothing new under the sun. But I think what has accelerated is the use of single district judges issuing injunctions that are nationwide.
That's where I was going next.
I knew it. They're nationwide in scope. There used to be a rule that you would sue, the district court might rule in your favor, or you might lose, you would appeal, and then maybe 2 years down the road, there'd be a split among the courts, and the Supreme Court would grant review.
Right.
This is what's called percolation. Think of like percolating a pot of coffee. Not today. Now a single judge in Maryland or San Francisco or Brooklyn or Brownsville issues what's called a nationwide injunction that immediately stopped globally whatever policy the president's taking. And that requires immediate review by the appellate courts, and in some cases, immediate review by the Supreme Court. Now, there's a chicken and egg problem, right? Is it that because there are these aggressive policies, you have these nationwide injunctions, or because you have these nationwide injunctions, you have these aggressive policies? I don't know which came first. It's beyond the scope of this program. But what we're dealing with is a sort of immediate nationwide lawsuits after every single executive policy with not a delay in sight. I think at some point the Supreme Court will discuss these nationwide injunctions and perhaps rein them back. I'll give you an example. Sanctuary cities, right? The president said, I'm going to withhold money from Chicago, which is a sanctuary city. Mm-hmm. The judge said, aha, I'm issuing a nationwide injunction. You can't withhold money nationwide. Now, why does that have to be nationwide, right? San Francisco can bring its own lawsuit, and New York can bring a separate lawsuit. So I think you're starting to see that they're starting to craft more narrowly tailored rulings that allow a government to function, whereas you have these massive nationwide rulings that are very hard to comply with in short notice.
Yeah, I have a slightly different take on I know this has been a topic of much concern in the legal community. Justice Thomas is particularly unhappy about it. But in my view, these are less about geography than they are about who is parties to the case. So a court has the power to issue orders that apply to the parties before it. And if the party before it is the federal government, and the judge's decision is the policy that you have implemented is unlawful, and I am therefore enjoining you from implementing this policy, well, it shouldn't matter where that's happening. It's not that it's saying this is nationwide, it's saying this applies to the federal government because that's who got sued. So I guess I find it both less problematic and also sort of confusing in the way that this has become discussed as more of a geographic problem than a parties to the lawsuit problem.
All right, do you think the Supreme Court's going to rein it in?
I think they might. I mean, recently the Ninth Circuit sort of narrowed down a nationwide injunction that had come out of a district court. So the appellate court said, well, maybe not nationwide, but maybe just within this particular circuit. So I think the lower courts are getting the hint that the Supreme Court is not particularly excited about this trend. And so it may be that that has a deterrent effect, that the court doesn't have to necessarily address the question, but it wouldn't surprise me if they did.
Josh, are they going to hear something this term on shutting this
Well,
down?
look, there's so many cases. There are cases involving asylum. There are cases involving the border wall construction. There's cases involving what's called the stay in Mexico policy, the wait and entry. There are all these policies, and every single one of these are basically nationwide in scope. And they're also applying not just the plaintiffs in the case, but they apply to everyone. So in other words, let's just say 5 people file this lawsuit in San Francisco. The court says this applies to the 5 people in this lawsuit and also anyone else at the border coming into the United States. So it's not just applying to the government nationwide scope, it's all possible plaintiffs as well, which is why these injunctions are so broad. It's not limited to those who are actually in the court. I think in one of these asylum cases, you may actually see a tightening up of the scope of these injunctions.
Yeah, if it's not reined in, is it y'all's expectation when the next Democratic president takes office that there'll be myriads of lawsuits filed on all the Democrat decisions?
Yep.
I can't imagine that would happen.
Of course, yeah. It's a mirror image. You just switch sides every 4 years.
It really is. Okay, we're down to our last 3 minutes. I wanted to ask you each, what would you think was the most important decision of the last term of the Supreme Court?
There was a case involving the U.S. Census, and you might remember that President Trump and his administration tried to add a question to the census. Are you a U.S. citizen? It might sound really simple, and of course, how can they not ask about this? But this was a case where the government didn't quite do it the right way, to use Emily's phrase, and this justification they gave didn't make a heck of a lot of sense. And the court, by a 5-4 vote, said that there was not a good enough reason to ask this question, that the reason they gave was simply preposterous. It didn't make sense, and it was not reasonable. As a result, that this question was not added to the census. I don't know how much impact this actually has, because the information on citizenship can be gained by other means. But this was a case where the Chief Justice was willing to tell the administration that you did it wrong, go back to do it again, and I'm not going to let you do it. And they lost.
Emily, do you think what happened when they made this decision is there was a discussion and somebody said, I think that we need to have the citizenship question back? And somebody said, okay, great. And that was it. There was no why. There was no articulate reason. And then when the courts, they get in a lawsuit and they said, hey, wait a minute, what was the basis of you adding this? Is there a basis? Which, by the way, you can make a logical case of why you'd want to hear it. Nobody did.
Well, I think there's actually a lot of evidence that they knew exactly why they were doing it, that the question would help non-Latino white Republican districts be counted more populously as compared to minority districts, because minority communities are often afraid of talking about citizenship status, even when they are citizens. They might have family members who are not citizens. And so in the litigation, it never got fully explored, but there had been some evidence that had come out that there was a very conscious effort to try to use the citizenship question to suppress minority participation in the census, which would then have an impact on how House seats are allocated and how federal funding is allocated as well.
As opposed to like finding out how many citizens are in the country, generally?
There are all sorts of ways to do that.
Yeah, well, yeah. So what you're saying is it appears the reasons were too political, as opposed to these are important statistics. We need to know. We need to know how many people are in the country. How many are citizens. We know how many are permanent residents, etc. So yeah, it sounds like again they didn't make any decisions. Okay, well our time is up. Josh Blackman, Emily Berman, thank you so much. I think you were both fascinating and interesting in terms of talking about what's happening. It's going to be a fascinating term. We'll try to have you back after the term ends next June.
I'll be
right?
right
I'm
here.
sure there'll be other decisions and fascinating. And we'll be back next week on Red, White, and Blue.